Welcome back, and we are getting ready to move into our second conversation for today, and we're talking with the president of the Christian Workers Union, and we're going to be talking today about some of the common questions that are asked by workers about what the labor law dictates for them. And we have with us Dale Trujeque. Good morning and welcome.
Good morning, and thanks for inviting me back.
That's right.
Now, when we look at the labor laws, it's a set of do's and don'ts essentially that govern employment and employees and employers as well.
Yeah.
What are some of the most common concerns coming from employees at this point?
Okay. First, let me clarify for people that you're in the private sector. There are two legislation that governs employees. There is the Labor Act, which is the primary legislation, and then, but a lot of people don't know, like drugstores, the fuel stations, those some of the small shops, those are governed by the Shops Act, which is a very small little document, but a very complicated document. And that document in particular is one that I'm certain needs to be revised, and I'll explain to you why. Because it goes right to the heart of one of the big issues that is coming up with the Easter weekend. One of the primary issues at Easter weekend is how you pay those holidays. Now, this is one of the most
If there was a most asked question to the Labor Department, it would be to explain this particular issue.
Not only that, question I get is, what are the holidays at the Easter weekend? People don't realize there are 3 holidays. There is Good Friday, there is Easter Sunday, Easter Monday. Those are the public holidays. Saturday is not a holiday. It's treated, I think, by everybody
like a
as a
holiday.
holiday.
Because you group the holidays together as one long
Pack up and go. Go for 4 days. But interestingly, people who work at fuel stations, I'm going to look at that group, especially a good number of people are employed at the gas stations, as we call them. When they work those holidays, if those holidays fall on a regular scheduled work day, which Good Friday is usually a regular day.
Friday and Monday.
Monday is usually a regular day. They don't get any additional pay for it. Ma'am, that's my problem with that legislation, because that discriminates against them, the people who work. Drugstores can open because they don't incur the extra cost. But when you go to San Pedro, and I must clarify, Shops Act only cover shops and businesses in areas that are identified in the schedule, which would be like mainly in the city and the towns. So
urban areas.
Right, urban areas. So outside of that, you wouldn't be covered. If you notice, when you go to San Pedro on an Easter weekend, it's hard to find a restaurant open on the Easter weekend. And I believe, I'll maintain that problem has to do with what employers have to put out. Right? Now, for those not affected by the Shops Act, those not governed by the Shops Act, you govern by labor. Well, these are the big overtime thing. How do you pay? Regular hours you work, you pay at straight time. Whatever the regular rate is, if it's $4 an hour, you pay $4 an hour for the hours. For the hours actually work on a holiday, like the weekend coming up, the big weekend coming up. Say I work 8 hours, I would have to pay on Good Friday. Well, let me make it easy for the people listening. There are 3 double time holidays in the country.
That's right.
There's Christmas, Good Friday, and Easter Monday. Those are the big double time holidays. And they're the only 3. So the easiest way to remember is to just memorize those 3, because everything else is time and a half.
Yes.
Right? So if I work 8 hours on one of those days, and you're not governed by the Shops Act, you get paid double time.
You get paid for 16 hours.
Right.
Yes.
And the other holiday, like say Easter Sunday, you'll be paid at time and a half. Right.
Now let's break down time and a half, because this has been, and we've had this conversation previously on the show. a great challenge for persons because the way it is interpreted by different institutions is different. So what does the law actually say about time and a half?
It's interesting because when I was at Labor, you didn't have the amendment that came into effect in 2011.
Yeah.
At Labor, you're taught, based on how the law read, that if I work Easter Sunday, it's a public holiday, time and a half day, I work 8 hours, I'm to be paid my holiday pay, if that it was a regular schedule work day for me, right? So my holiday pay would be a regular work day pay. If I get paid $4 an hour, 8 4 is 32 if it's an 8-hour day. That's a holiday pay. But say I go in and I work 6 hours, but someone want to work 6 because you feel the pinch. I'll get the $32 plus the 6 hours at $6, which is the time and a half, which is an additional $36. That is how it used to be done prior to the amendment. Now I've read the amendment in number 3 of 2011, the Amendment Act. And basically, the Labor Department says you only get paid the time and a half rate, right?
And time and a half translates into, let's use
So
10, that's an easier number to, so you
Yeah,
get paid
you
$10
$10 an hour.
Yeah.
So the Sunday is a regular work day for me, say for the call center people, because some of them work 7 days a week, right? So according to the interpretation of the department that I understand, because I've called them about it too, just to be on
Yeah.
the page, because I'm wondering why they amended it.
Yeah.
For me, the amendment doesn't clarify. The amendment just makes it,
More negative.
yeah, you muddy it more. But let's go with what they say. They're saying that the way the law reads now, if I work 6 hours on Easter Sunday, and it would have been my scheduled work day, regular scheduled work day, I'm going to be paid for that 6 times 15, because she's saying it's $10 an hour, just make it easy for the people out there. So the time and a half rate would be, case time and a half, $15. It would be 6 hours times $15, it would be $90
Yeah.
a day.
So you get your regular
Days.
salary plus half of what your regular salary is.
Yes.
Versus what many people have been believing for a long time, which is your regular salary plus your regular salary and half more. Right?
Now the thing is, what I gave you was the Labor Department's interpretation of the amendment,
Yeah.
right? That thing is open to contest in the court,
Yeah.
because I've read it over and over, and I don't see the difference with previous sections.
So what is your recommendation to a worker? Because I know sometimes you have change in staff, sometimes you revise policies, that perhaps I have been being paid the time and a half as it used to be before. In other words, my regular salary plus 1.5 more. And now somebody has interpreted it in the opposite fashion, that I would get a regular salary plus half more. What can a worker do, or is there anything they can do about that?
The only thing, because the worker will call the Labor Department,
Absolutely.
and the Labor Department will give you the interpretation that I have gotten more
Yes.
than once. But a worker not satisfied, who can read the legislation for himself or herself, the only option then is to challenge it in the court. See that the Labor Department's interpretation is wrong, which is what the law is about. The law is about lawyers fighting over interpretation of the legislation and the different laws.
So let's go back to some of the other commonly asked questions of the Labor Department. Let's put this in context as well. We know, Mr. Trujeque, you've had a lot of experience as a labor officer yourself, so you've taken many concerns from workers about what takes place within the workplace. And I want to touch on one of the main ones, which is people are very fearful of having employers know that they're accessing information from the Labor Department. But there is a confidentiality clause set out for persons who work within the Labor Department. Is that right?
Absolutely. Absolutely.
So what do you say to people who have questions or concerns, and when the labor officer says, well, please tell me your name or what institution you work at, and they want to hang up? Let's talk about that.
It's a tricky position for any labor officer to be in, and I think all of them have been in that position. I've been in that position. And the only thing you can tell the worker is, listen, one, the law requires, the law stipulates that I keep your confidence, right? 2, if you have a complaint that I may have violated your confidence, you have the right to complain to the commission. I used to tell people this, right? I used to tell people this, right? So the other thing is that you can, how should I say, you can tell the worker the only way you can help the worker
Yeah.
is to go and do an inspection or go and visit the premises. No, the worker has a right to visit the premises, and the employer and the labor officer has an absolute right to visit any premises at any time of the day or night. He carries a warrant, right? So when you go, and this is a position I have been with. I have visited workplaces, and the same worker that came to me sees me now with the employer. What you think goes through the worker's mind? The worker forgets that I have to go do an investigation of a complaint. The worker feels there's hanky-panky.
Collusion.
Right. And this happens a lot.
Yeah.
This happens a lot. And it's hard to dispel that fear, which is a genuine fear. And what I want to ask workers is, if you're going to come to the labor department to complain or to ask them to go and look at a matter for you at a job, then please trust them. Trust them until they have shown they can't be trusted, because there are other venues to hear that, right? To hear your gripe about the labor department.
Let me ask you a question here, Dale. The idea of job description and what seems to be an open-ended clause at the very end of your job description that says, and any other duties are so assigned. I think people have a problem understanding the parameters of that, simply because it's open-ended. For instance, if you have a clear set of guidelines that say this is what you do from 8 to 5 on a normal basis, and then your employer, your manager, your boss comes and says, okay, I need you to do X, Y, Z in addition to this set of responsibilities, so to speak. How does one deal with that in the context of what they're ordinarily used to doing? To say, well, what is excessive or what is within the confines of that?
Okay. The way I understand it, let's back up a little bit. I want workers to understand that the employment relationship is a contract. When you tell workers that, they're like, but I not sign nothing. No, the labor law refers to employment relationships as being oral or written. So you accept my job, you come work the Monday, and I say, all right, you could come and be an office admin. So you come in the Monday. By showing up, you accept my job. Now when you come in and tell you want to do A, B, C, D, lots, in fact, the majority of the complaints the labor department receives is because of oral contractual arrangements, right? The issue you brought up has to do with the written ones, where workers are given their job description and at the bottom.
And any other.
Now there's a
detail.
contract. I was hired to be an office admin assistant or something like that, or admin officer. But because there is not sufficient work for me, the boss say, you need for help, clean our map. Because at the bottom of, so you voice an objection, but boss, you hire me for be the admin assistant. So
Not janitorial.
not the janitorial thing, I mean your job, not that you can't help out. There's an issue. It's a conflict. How do you resolve it? My understanding of how it works is that any other duties from time to time is not broad, it's not open-ended. It can only be related to the job I hired you for. Because you got to go back to what you hired me for. That's a contract. I can agree to do it, to do the outrageous other, because I call them out. Some of the things
It has to be
people-
totally out of the scope
Yes.
of your typical work.
But I'm gonna tell you, once you start it, you don't keep to do it. And you'll become a part of your job after that.
And that is the problem that I have with it, because sometimes employers would ask in terms of, do this one time. Before you know it, it becomes fixed into your job description, but it's not done in a formal way, because that was never what we agreed upon. But then now all of a sudden, you either get to see this extra skill set that you never knew I had, and then you want to take advantage of that by fixing it in the job description.
That is a dangerous thing for workers to accept. I see dangerous, because you can wind up eventually with more little bullet points on your job description than what you originally started with.
And what you're getting paid for.
Exactly. It has to be a dialogue. It can't be an instruction.
Yeah.
Because like I said, if it's not related to my job as the admin officer or the admin assistant, then I can say politely, but boss, I don't agree to that. But most employers are of the view, when you accept my job, I dictate.
Yeah.
Right? Where the contract is concerned, what I agree to do for you, but you can't dictate. In fact, you shouldn't even be dictatorial, because that will create the adversity in the workplace. But we know how a lot of people behave. Outside of that, we can discuss if I want to help out, because I can look around, I can see I don't have enough work, or there's some time to do other things, you know.
Yeah.
That has to be worked out, but it should be negotiable.
So what is your advice to workers when they have concerns along these lines?
My thing is this. A lot of employers make it difficult for employees to be very honest. And so employees who take up the issue come across as abrasive, into assertive. But the employee don't get his view. If I approach my boss, talk about it, he don't expect the boss to snap at him or her. Well, that can't be the position, because that is where conflict starts. And you run the risk of losing very good workers that way. But then you want your worker to be honest. You want your worker to be faithful. Well, the mentality on the part of employers have to change in many respects. You have to be open to your employee coming to you and say, well, boss, I'm not certain. I encourage workers to go and talk about it, but not go fight.
Yeah.
If you go fight, you're going to lose. The man not the boss. You're going to lose.
So don't walk into the office or request a meeting to say, I absolutely won't. Have a discussion.
Yes, have a discussion. Have a discussion. Try and understand where the boss, maybe the boss...
Or strike a compromise.
Yes, because maybe things tight, but he want to keep you. Because they think, you know what, I just hired you the other day, but I look at the bottom line and not look like I could keep you. Because I need my place clean anyway. And that I need. So eventually I'm going to have to choose between one of three people. You might be the one. So maybe when you go and you talk to the person, you get to understand and say, you know what, I'm going to accept this. I'm going to roll with this. But you could say, boss, down the road, when things pick up, I would like you to take it back when you can afford to bring in a regular cleaner. Things like that. You have to try and...
That too is tricky though.
So
it's tricky. It is tricky.
This is the key part, because I heard you speak about it earlier, and I think it's an important follow-up point. A lot of times we make oral agreements. In other words, we discuss an issue. Maybe it is even to say, okay, I'll pick up the janitorial duties till the business picks up, and then you'll eventually hire someone. And business picks up, from my perspective, and a janitor is never hired.
Yeah.
How do you hold that employer accountable to what they have promised, given the fact that it's, even if we file a complaint with the labor department, it'll be what he says versus what I say.
And if you go to court, it's the same thing.
Yeah.
Right? Always
So what's your advice? Follow up with an email or something, get it down on paper?
Document it.
Yeah.
Document that you're doing it under conditions that eventually you take it back. And you can erode away the employer encroaching on your right to not do it. You can, maybe the employer asks you to do this cleaning Monday, Wednesday, Friday, and you notice it gone on a whole year. So you see, you know what, boss, come the new year, I got school or I got something, so only I could eat for you Monday and Friday. You keep showing that you don't really agree, and you have a right to say, I can't keep doing all of it. And like Marlene rightfully said, I always tell workers, document everything. Document everything, because when the labor department or you, because sometimes in certain offenses in the labor that the employee have to carry the labor, take the employer to court himself,
Yes.
or herself. So you
And
got
you
to
have to have
document.
the evidence, yeah.
Yeah, you have to document. Otherwise, the magistrate sits there, because most of them are magistrate court matters. And the magistrate will decide who to believe. But most of the times, the courts, in my view, have come across very fair. Right? Employers don't see it like that, but employers ought to understand the role of the labor law is to just minimize irregularities in the workplace.
Let me ask you a question here. On average, you work, let's say, 40, 45 hours a week, right? And then there's a scenario where employees are required to either work weekends or on a rotation basis. Once you've completed that 45 hours, is it mandatory that you would sign on to having to do the extra hours on the weekend, or is it optional, seeing as though you fulfilled what you initially signed up or agreed to do?
That's a loaded question. A loaded question. It's a loaded question because lots of employers just walk in, tell a worker, we gotta do the overtime. Or, half a work Easter Monday. But the labor law says in what you call obligatory language, no worker is obliged to work any overtime. No worker is obliged to work on any public holiday. Now that's tricky. That brings me back to that shop sack thing with those workers. The labor law said that it conflicts with where the shop sacks are for those shops. But we're not talking about them, but I'm just saying. But it says you're not obliged to work, which seems to indicate I have the right to refuse. But what happens if you refuse? You might lose your job.
But doesn't that then make it highly discriminatory?
That's why when they're reviewing this, they're revising this act, the people who know and where they feel it need to be involved. But the people who know and feel it are never involved. And usually it's the NTUCB that gives its input. There is no penalty in the act for an employer that forces a worker to work overtime, because the employer will never document how he did it. See, you don't get a memo telling you how to work. You seldom get that in a writing. I haven't really seen one yet. But the offense basically is non-existent. I don't know, in all my years, including the years I was at labor, I don't know of any employer being taken to court for an offense forcing a worker to work overtime.
Well, because we want to paint the reality of the situation here. We are living in a country with a problem of a high unemployment rate. There are people who want jobs, there are people who have jobs that really need their jobs. What this creates very often, and I will never say, because we have to be very fair, there are many organizations that are very responsible with their workers.
Oh, yeah.
But there are some that do take advantage. And there are some workers who are very uninformed of their rights, that they perhaps are not very clear as to where the boundary has been crossed or what the law has been broken. So you have an employer who comes in and says, well, nobody's going home tonight until we get this job done. You have your children to go take care of. You have many important things to be able to deal with, but you need your job. So you stay, not realizing that perhaps there has been some sort of infringement upon your right as a worker. So how does somebody who's watching this right now, and I know when it comes to labor issues, there are many people who want their questions answered. I can't tell my employer no, because I need my job. But I also have kids who are unattended at home while I'm staying to finish this work. What is your advice to them at that time?
Well, you can only advise the worker, right? You can't tell them what to do. In many cases, you'll find a worker sit and gripe. But the employer actually treaded on dangerous grounds. If he treads on dangerous grounds if he tells them nobody can leave. And he makes it clear that nobody will leave. Because that is done, that then goes over to the criminal side. That is an unlawful detention. And workers need to know that.
Yeah.
Your employer can't physically stop you from leaving the workplace. And the employer can call you for sit down in a room and make it difficult for you to leave the room because when you sign on a document. These things happen in Belize, all over the world too. So, but to answer the question, it comes down to a decision that the worker has to take. Am I going to, because you run the risk, the sword of Damocles that hangs over the worker said, I need my job. I need my job. That is the worker's reality. If I don't got my job, I can't go mind, I can't take care of the kids. The same kids I want to run home to talk to your employer. Listen, boss, nobody there in my kids. I got to pick them up now. After 6, I pay overtime. Because some people have to pay the OT. Some people have to go and get the children. They have no option. Well, I really need this done. We gotta get this. Well, boss, you mind if I go get my kids and bring them here? That's striking a compromise, right? Remember, boss, and I really have to do this. But bosses never want to hear, you don't have to work overtime. They think they have the right to do that, right? We have to encourage a dialogue. There has to be a common ground to be met all the time. And I think there has to be some sensitization by the Labor Department and the NTUCB in respect of making workers understand how to engage employers in an ongoing conversation. Because then what it will do, it will create a healthier workplace, right? People say, well, I can't make my employee question me. Your employee is not questioning you. Hold on, first, you don't know your child.
Yeah.
You know, it's a job. You're paying him to do something. Is he, by refusing to work overtime, is he taking away from essentially what you hired him for?
Yeah.
You, as the employer, go back to where you started with the worker and be honest with yourself. I will be honest with myself as the employer and make the worker be honest with himself or herself. If you start from that, I always say, keep things simple. Employer, keep things simple. Worker, keep it simple. You should be able to resolve it, but it requires a dialogue.
Yeah. Now, I also want to touch on one other issue that I know is usually a typical concern of persons, and the labor laws are actually very clear on this issue, and that is deductions from your salary. Let me just give you the opportunity to explain it, because I know if I work in a particular institution and let's say I'm short of cash, or there's some sort of infraction that takes place, and I'm told it will be deducted from my salary. What is your recommendation to workers? In fact, it cannot be done. Let's be very clear. It should not be done.
It can be done. Section 105 of the Labor sets out what it calls, I think it refers to it as unrestricted deductions or illegal deductions. And then section 106 sets out what are the legal deductions, which are like Social Security,
That's right.
income tax,
Deposits,
money for uniform.
authorized. You have to authorize some of these.
Yes, like I want you to wear a uniform, I'll pay for part of it and you pay the rest. You authorize the deduction. But where the law says you cause injury to property, the employer's property, and the word injury is used in a legal way, could mean all kinds of things.
Yeah.
You work cashier. That's one of the commonest ones.
Yes, it is. Yeah.
You're shot,
the pan.
you come out with the money.
Yeah.
It is clear-cut illegal, and the law not only says it's illegal, the law says the employer cannot make an agreement with you to pay it back. It can't make you sign. Basically, it covers every corner the employer might want run through or run into to say cover himself. You can't.
Even if you sign something to say if I am short,
To sign
you will
is illegal.
deduct it.
To sign
It
that
is not
is
legal.
illegal. That
Now-
is illegal.
From I understand it, the purpose simply is that salary is based for the time that you've worked, and if you've served that time, you deserve that salary.
Yes.
So no matter how much money is short, no matter what equipment is broken, damage to vehicles if you're a driver,
I'll talk about a case like that right now.
It cannot be taken out of your salary.
It can't come out your salary. Period. There, in my time at the Labor Department, there have been some very interesting cases with big employers in this country over the same issue. And you make enemies, you know. You make enemies as a labor officer when you go after those things. I know a case right now where a guy, this happens a lot. You would be surprised to know how many of these cases exist. Where a guy had an accident, employer vehicle. I understand the vehicle got total, but I also understand he was not in the wrong. See, matter had to go to court, but the employer has a comprehensive insurance on that vehicle.
Yeah.
Now the worker noticed, like about a month after, every
They
month,
start come
well,
up sharp.
175 they come out I pay every week. So he gonna question it. Employer telling you gotta pay back.
But the vehicle is already comprehensively insured, so isn't that
But
double
beyond
dipping
that-
in a
This-
sense?
yes,
Yeah.
but this
It's double
happens.
dipping.
That's the dishonesty of employers. This happens.
Yeah.
So I explained to him, I show him the law, and I explained to him, you want to go recover this? We have to go. Because cases like that, the Labor Department normally will take a little while to process, but they ought to take it. But you, the worker, you
Have to know your rights.
you can know, you must know your rights.
Yeah.
And the onus also is on you to have it remedied. So you don't have to wait on labor, you know.
Two things I hear there that I think is absolutely crucial as we start to wind down this conversation. One, as an employee, we need to know our rights.
Yes.
Secondly, when it comes to issues of salary deductions, you will only know what's being taken out if you have a pay slip.
Yeah.
And if you watch and monitor your pay slip,
Yes.
which I know quite a number of people don't do.
They
You are
just
required to get a pay slip.
do away with it.
Well, what the law says the employer is required to keep a record of the pay.
Okay.
So you can make you sign a book for it where everything is listed there. But before you sign, you should check where you sign for.
Yeah.
Now, a lot of people are going to computerize their automated pay slips, which is great. I'll tell the employees, keep pay slips, keep sick paper, keep copies of everything. You never know when you will need it. It comes up. So the pay slip ought to document what happens to every penny in your salary,
Yeah.
right? Amen.
Okay. So as we close off, what is your recommendations to workers about being able to ask the questions if there's a concern, and also to be able to do what is necessary as a worker? One, to maintain their job, but also to ensure that their rights are infringed upon.
My recommendation is speak to people in the union business that we are. Go to the Labor Department for advice, but try and learn to just approach your employer. Lots of times, I know employers when I like care workers voice their concerns, but they take it in stride, and those are the ones that know better. So they listen. Right? They may not do what the worker want, but they take it in stride, right? But then you have the ones who workers can't tell anything to. The penalty is coming, you're gonna lose the job. But if workers make that continuous effort to talk, to engage, and that's the thing, we gotta teach our people how to do this, how to keep conflict at the minimal level possible.
Yeah.
You can't take conflict out the workplace completely. We will get better at this, and we will improve what is going on out there. Because I'll tell you, I just told someone this, there are more labor offenses in this country than crimes. And we need to understand how labor offenses affect people psychologically.
Yeah.
Especially when a worker know you're the chancer. And I want employers to think, you chance a worker, it's a two-way street. I'm not here to condone, but for remind employers of the reality. A lot of employers will tell you about pilfering on the job. You need to ask yourself why pilfering is always a big problem for you.
Yeah.
Because it's a two-way street. what are you doing that
Yeah.
puts your employee in that position where you find a way to get it back? That is wrong.
Yes.
To stealing is wrong. I'm not condoning it, but you have to remember we are human beings. And so there is a psychology at work in the workplace also. You can write stories and stories about all the issues we encounter.
Well, we appreciate you coming in to talk about these specific issues, and we would love to have you back again to be able to explore more about what our labor laws dictate, and most importantly, workers' rights, but also responsibilities that come on the job.
Yes, the responsibilities with the rights, absolutely.
So we will tackle those another day. Thank you for stopping in, Mr.
Thank you
Trujeque.
again, guys. Thanks.
All right.
Anytime.
We're going to go ahead and take a break, and we're continuing our conversation with the Women's Month and the celebration of Women's Month. This time we're talking about the men's role in female empowerment. That's coming up after the break.